But Ripple's difference compared to all the other blockchains is that other blockchains is a decentralized model, which means that no one party controls it, whereas Ripple is a centralized model. So they want regulation. They want to basically plug into the government system, use blockchain as a technology by way of payments getting transferred in an instant manner. When I saw you sort of talking to Ripple, and I was like, oh, because I haven't followed their case lately, I didn't know whether they had a positive outcome or negative outcome, but the fact that you were talking to them, I thought they must have had a positive outcome. And then if their payment system are launching here in Australia or are offering as a legitimate commercial business offer, it's very interesting. It'd be very interesting for the likes of me as well, right? Because it will make cross-border payments and so forth a lot more efficient.
After an earlier judgment in favor of his company was upheld by the court in an ongoing litigation, Ripple CEO Brad Garlinghouse has taken a new shot at the U.S. Securities and Exchange Commission. Ripple's payment initiative in Singapore has received major regulatory clearance thanks to Ripple's efforts. In addition, is a compromise between Ripple and the SEC even feasible at this point? After printing a 4% climb to retest the 52 cents price, XRP is now on the rebound as the current growth trajectory represents a huge reboot for the coin. XRP's price is expected to continue to rise. Ripple, who recently lashed out at the United States Securities and Exchange Commission after a judge in the United States District Court once again decided in favor of Ripple. In a ruling that was issued in July, Judge Annalisa Torres concluded that secondary XRP sales did not constitute securities transactions. The SEC filed an interlocutory appeal to the decision, but it was denied on Tuesday. In the most recent verdict, the SEC failed to present a solid basis on which the court may have overturned its earlier decision. As a result, the court upheld its original ruling. Throughout the entirety of the case, the court discovered a number of contradictions in the SEC's assertions. As a direct consequence of this, the court ordered the government agency to wait until other aspects of the litigation were resolved before it could appeal any of the rulings. Ripple's CEO, who has a tattoo on his arm depicting XRP and the date of the court judgment in July, made fun of the SEC while providing commentary on the most recent court verdict. The CEO of Ripple claims that the SEC was defeated at its own game despite the fact that he does not have a legal background. In its lawsuit against Ripple, the government agency had demanded that the judge adopt the well-known Howey test. Nonetheless, it was ultimately unsuccessful. According to the chief legal officer of Ripple, the judgment that was given on Teen regarding XRP's win continues, which once again confirms that XRP is not a security. The SEC's two-pronged case has been weakened by the most recent judgment from the court. The agency had reasoned that programmatic sales of XRP might investors to expect gains based on Ripple's effort, and that Ripple's other token distributions constituted an investment of money by recipients. Additionally, the government said that investors could expect earnings based on Ripple's efforts. However, in her most recent order, Judge Annalisa Torres stated that the SEC did not give a meaningful cause to contradict the earlier findings that were made in the ruling that was issued in July. In addition, the judge came to the conclusion that the issues in question do not present purely legal concerns that could be easily resolved without first conducting an exhaustive investigation of irrelevant factual documents. Before the SEC can proceed with an appeal, it is necessary for the court to rule on other issues that are connected to the larger complaint it has brought against Ripple. According to what has been published, the next hearing is scheduled for the 23rd of April 2024. However, the parties are required to submit pretrial documents no later than the 4th of December 2023. Please do not forget to subscribe to our channel, and also hit that notification bell if you want to be the first one to get more updates regarding the most recent occurrences in reference to XRP. According to earlier reports, the concluding pretrial conference is slated to take place on April 16, 2024. It is important to note that the parties and their respective counsels are required to physically meet for at least 1 hour in order to explore the possibility of reaching a solution. The court has directed that prior to the conclusion of the pre-trial conference, counsel for both parties as well as the parties themselves will meet in person for at least an hour to consider the possibility of reaching a settlement regarding this case. The instruction that was issued by Magistrate Sarah Netburn, the judge in charge of the pretrial proceedings between SEC and Ripple, is followed by this order. Therefore, it is consistent with that directive. Shortly after the court delivered its decision about the summary judgment, Judge Netburn directed the parties to designate 3 days for a settlement conference that would be mutually convenient for all parties involved. If the parties agree that a settlement conference would be fruitful at this time, then and only then are they obligated to choose the dates. Nevertheless, The judge issued an order requiring that the chosen dates for the upcoming conference be submitted to the court at least 6 to 8 weeks in advance. Therefore, it is required of the parties to submit 3 potential dates for the consideration of a settlement between 6 and 8 weeks before the pretrial conference that is planned to take place on April 16, 2024. To what extent, then, is the settlement still doable at this point? In the case brought by the SEC against Ripple, there have already been 2 attempts at reaching a resolution. Despite this, neither of the meetings led to a resolution of the legal dispute that was being pursued. It is important to note that the prior settlement talks were held prior to the court issuing the summary judgment on July 13, 2023. Ripple has made it clear that it is open to settling with the SEC provided that XRP is given more clarity. It is intriguing to note that the court has already ruled that XRP is not a security. On the other hand, the court declined to grant the SEC's request to challenge Ripple's success by filing an instant appeal against it. Therefore, in order to submit a comprehensive appeal to the Second Circuit, the SEC will have to wait until the lawsuit is settled before doing so. According to a previous report, legal analyst Scott Chamberlain hypothesizes that the SEC will have a more difficult time winning an appeal at this level of the process. In addition, he stated that in light of the recent judgment rendered by Judge Torres, it is highly doubtful that the case will be taken all the way to the Supreme Court of the United States. The fact that the court has ordered the parties to negotiate a resolution to the conflict means that the upcoming conference, in contrast to many that have come before it, may produce fruitful results. In addition, the company recently announced in a statement that Ripple Markets APAC, its subsidiary in Singapore, has been granted full authorization to provide cryptocurrency payment services in the Singaporean market. This news was included in the statement. The Monetary Authority of Singapore, which is Singapore's most important banking regulator, has given Ripple the all-clear to operate as a payment institution, or MPI. Ripple reaffirmed its dedication to providing businesses in Asia and the Pacific with crypto-based solutions that are applicable in the real world in a tweet. In addition, Ripple emphasized that the important success demonstrates the practical application of crypto solutions, particularly as they relate to the provision of services to financial institutions and businesses. In addition, Ripple noted that the license is a significant step toward the company's ultimate goal of achieving widespread acceptance and utilization of cryptocurrencies. The payment company highlighted Singapore's leading role in terms of the regulation of cryptocurrencies. According to the statement, Singapore is widely recognized as a pioneer in digital asset regulation, which makes it an ideal site for businesses and financial institutions to take advantage of the power of cryptocurrency for international payments. Additionally, Ripple's chief executive officer, Brad Garlinghouse, offered his thoughts on the regulatory achievement. He emphasized the significance of Singapore's part in the expansion of the company's global business during the past 6 years. According to Garlinghouse, Singapore has become one of the top hubs for fintech and digital asset businesses because to the leadership of the MAS. This achievement represents a successful balance between innovation, consumer protection, and responsible growth. Notably, this full major payment institution license arrives just 4 months after Ripple received an in-principle permission from MAS. This is an important development. It is important to note that the license catapulted Ripple into an elite league of less than 20 companies recognized in Singapore for providing crypto payment services. During this time, Ripple noted in the release that there will continue to be a trend toward digital payments in the Asia-Pacific region. It was also highlighted that cashless transactions are predicted to soar over 109 percentage points by the year 2025. According to what has been published, a request for an interlocutory appeal from the United States Securities and Exchange Commission has been refused by Judge Annalisa Torres. This outcome was something that many crypto-friendly attorneys have been predicting for some time now. This highlights the importance of the verdict. That's all for now. Thank you for watching.